amazing welcome, but please be seated.
Good job, everybody. Good afternoon. I'm Susan Carter, President of the Board of Directors of the National Women's Party. Welcome to all of you. Thank you for joining us on Women's Equality Day in this incredible historic place for this important conversation. Justice Ginsburg, on behalf of the Board of Directors and all the leaders who are here today, we are truly honored and grateful that you're here to share your reflections with us. Your determined and tireless efforts to expand legal equality for women are an inspiration to us all. Thank you so much for joining us today. I'd also like to welcome our moderator, Jill Morrison. Jill is Executive Director of the Women's Law and Public Policy Fellowship at Georgetown University Law School. She also directs the Leadership and Advocacy for Women in Africa program at Georgetown and is a professor there. Jill, thank you for moderating today. On behalf of the board of the National Women's Party, I also want to express our appreciation to all of you for being here with us today and for the work that you do to carry that torch forward. We really appreciate it. A little bit of history about us. Founded in 1913, the National Women's Party, led by Alice Paul, played a groundbreaking role in achieving women's constitutional right to vote. Our members mobilized across the country in support of women's suffrage using many of the same tactics that we all use today: marching, picketing, organizing, getting involved in political campaigns to advance women's rights. Following ratification of the 19th Amendment, the National Women's Party fought for full constitutional equality for all women, including drafting the Equal Rights Amendment in 1923. As early as 1920, members drafted legislation to end labor discrimination and pay inequity, fought unequal laws related to marriage, citizenship, and property rights, and organized international women's rights campaigns. As the 100th anniversary of the right to vote nears, we in the NWP believe it is important both to understand our history and to support the work that remains to advance women's rights. So in honor of the upcoming centennial and the brave women on whose shoulders we stand, the NWP is renewing its commitment to help achieve full constitutional equality for women. We look forward to working together with all of you to achieve that goal. Now, let's get on with the program. As a reminder, please refrain from using electronic devices during the program to avoid any disruption or distraction. We will post the full video of tonight's conversation online. Following the program, we will have remarks from the National Women's Party Executive Director, Zakiya Thomas. After her remarks, please stay in your seats so that we can do a group photo with Justice Ginsburg. And with that, Justice Ginsburg, Jill, thank you again. Turn it over to you.
Jill, before we begin, can you hear me? I don't know if this microphone is working well. So what can we do?
We can move it a little.
That's better?
Yeah.
Okay. I did want to mention one person instrumental in the National Women's Party. You all know about Alice Paul, but how many know about Bernita Shelton Matthews? She was counsel to the National Women's Party, and she was she was going to law school at night, and she would go to the White House to picket. She'd hold up her sign that said "Votes for Women." She would never talk if she was hassled by the police. She would just stand her ground. She didn't want to talk and risk getting arrested because that might hinder her membership in the bar. I speak about her because I met this remarkable woman when I was appointed to the DC Circuit. She was the first woman in the country to be appointed a federal district judge. That was in 1948 by President Truman. When I met her, her eyes were dim, her hearing was poor, but she had all of her mental faculties. And she is responsible for getting the largest condemnation award ever paid by the United States up until that time. It came about because in the 1930s, Chief Justice Taft decided the Supreme Court should have its own building. The National Women's Party headquarters were not here. They were across the street. And it was part of the property that needed to be taken by eminent domain so that the Supreme Court could be built. The government insisted that it was a ramshackle old building, not worth anything. Bernita Shelton Matthews said this was the Capitol. When the Capitol was burned in the War of 1812, it was the temporary Capitol. The government said, still, it's just a worthless building. Bernita Shelton Matthews then introduced. She had said that this building was used as a prison for notorious Confederate spies. The government denied that. She called as a witness a member of the older inhabitants of D.C. who said, yes, this was a prison for Confederate spies. Then she introduced a photograph of a notorious Confederate spy, who happened to be a woman, inside the building. And with that, the government decided it would switch rather than fight on, and Bernita Shelton Matthews got that huge condemnation award. As a district judge, she would hire only women law clerks. Why? Because the male judges hired only men. And she told me she had the best law clerks on the district court. I just wanted to, as a preface to our conversation, mention this remarkable woman who did so much for the National Women's Party and for the country when she became a district judge.
Thank you so much for being here with us, Justice Ginsburg. So that reception that you received, one of my fellows identified what it is about you that really evokes such spirit among women. And she said that it's because you embody a past where women were legally second-class citizens, a present where you are advancing women's status under the law, and a future where the possibility for girls look very different than when you started your career. And I also think this space invokes some of those same feelings of the past, the present, and the potential of the future. And I know you've been here to the museum before, so I would just like to hear your reflections on being in this space.
On being in the headquarters of the National Women's Party. The first time I came here was in 1975. It was the day before I was to argue a case in the Supreme Court, the Weisenfeld case. It was about a man whose wife died in childbirth, leaving him the sole surviving parent of the infant. He had heard that the Social Security provided benefits for a child in care of a sole surviving parent. When he applied, he was told, sorry, these are mother's benefits, they're not available to fathers. My argument in that case is, on the surface, it seems like it's discrimination against the man, but where does it begin? With the woman as wage earner. Stephen Weisenfeld's wife was a math teacher in high school. she paid the same Social Security taxes that a man paid, but her Social Security payments didn't net for her family the same benefits. So it starts with discrimination against the woman as wage earner, the male as parent, and the baby who doesn't have the opportunity for the care of a sole surviving parent if that parent is male rather than female. There was a unanimous judgment in favor of Weisenfeld. The majority went on the ground that this is discrimination against the woman as wage earner. A couple of them said it's discrimination against the male as parent. One, who later became my chief, said it's totally irrational from the point of view of the baby that the baby should have the opportunity for the personal care of the sole surviving parent, only if the parent is female, not male. Before the Weisenfeld case, I came here and I was shown around. I sat in Alice Paul's chair. I was invited to stay overnight, but that was before the building was renovated. And it wasn't, I needed a good night's sleep, so I went to a hotel. But I just wanted to touch base with this National Women's Party that valorously introduced the Equal Rights Amendment. Was not successful. And what we were doing in a series of cases was to attempt to use the Equal Protection Clause to get us almost to the same place we would be if we had an Equal Rights Amendment. Well, that was my first visit here. And after I visited here, I was sure that I would prevail in this case. And as I just said, it was not just winning, but it was a unanimous judgment.
Wonderful. So you've written a few articles over the years about the need for the ERA, and one is reprinted in my own words. And you've, of course, noted that the ERA would give the Supreme Court a more secure handle in its support for equality. But as you mentioned, as both a litigator and in your time on the court, you've actually built precedent in that area. So could you explain why you believe that the ERA is still as needed today as it ever was?
There's one, do I have my, do you have my purse? Oh, here. Let me see if I have my pocket constitution. There's a problem with the 14th Amendment. Let's see if I have my pocket constitution. I hope I have it here. Someone has one? Okay, why don't you pass it to me? Yes. Good. Okay. The problem with the text of the 14th Amendment is the second section. The first section is fine. But then the first section includes the Equal Protection Clause, and nor shall any state deny to any person the equal protection of the laws. But the second section, which was meant to deal with states that did not allow African American men to vote, and it uses, for the first time, the word male is in the second section. It speaks of if you deny to any male inhabitant the right to vote, then your representation in Congress will be reduced. So it was that second section it was feared that that would be read as a limitation on the first section's equal protection clause. And the suffragists of the time, in fact, opposed the ratification of the 14th Amendment because of that second section and the introduction of the word male. And so that's the infirmity, that if you ask the drafters of the 14th Amendment, did you mean to change the differentials in the law between men and women, they would say no. This 14th Amendment is for race, it has nothing to do with gender. So it's that history that makes the 14th Amendment not as satisfactory as the Equal Rights Amendment, which is designed specifically to make women people of equal citizenship stature in all aspects of human activity. Another reason why I am a proponent of the Equal Rights Amendment, every constitution in the world written since the year 1950 has a provision among human rights guarantees that men and women are persons of equal citizenship stature. Our Constitution should have explicitly such a provision. And just like freedom of speech, freedom of the press, a fundamental tenet of our society should be the equal citizenship stature of men and women, and that's what the Equal Rights Amendment would do. Now, when I take out this pocket Constitution and show it to my granddaughters, I can't point to a provision that says explicitly men and women have equal rights and obligations under the law. So I would like to be able to take out my pocket Constitution and show my grandchildren. Jill?
And someone now has a copy of their Constitution that has been held by Justice Ginsburg. So moving from the 14th Amendment to the 15th Amendment, which of course theoretically gave Black men the right to vote, we all know that that was a point of outrage for some suffragettes. And I know that you're a great admirer of Pauli Murray, who identified the ways that both the women's rights and the civil rights movements were not meeting the need of those who hold multiple identities. How do you think the women's movement might have evolved differently if it had actually started as more inclusive and intersectional?
Well, let's go back in history. Many, many women were both suffragists for women and abolitionists. If you think of the Grimke sisters, for example, they were prominent abolitionists. Then, what first outraged the women? They went to the anti-slavery convention in England, and they were told to sit in the back and not to speak. There was a historian, Anne Scott. She was a professor at Duke, and she was president of Duke University. She said when she was doing her research into the abolitionist efforts, she came across dozens of petitions by women, and she thought she had made a great find. And then she discovered that her male colleagues had also found these petitions, but they were women's petitions, so they were not of importance. think, well, Paulie's point, Paulie certainly would have applauded the first Title VII case. Title VII, I think you know, is the principal anti-discrimination in employment statute that we have. It was the case of Ida Phillips against Martin Marietta. Ida Phillips worked for Martin Marietta. She had a child. She was fired because the company had a rule, no women with preschool children. Of course, a man with a preschool child, that was fine. Ida Phillips was a white woman, but her case was taken by the NAACP because they realized that if they could break down that barrier, that women with preschool children are not employable, it would be of great aid to African American women. So I think that as Title VII developed, precedent for race became useful in gender discrimination cases and the other way around. So I think there has been what you call intersectionality. I think Ida Phillips' case is a good example of that.
Are there specific actions you believe that the movement can take today to make sure we are maximizing the power of being inclusive and diverse?
Action, well, one is what the precedent set by Ida Phillips' case, that example. I would say something else. People who are left out are poor women, and many of them are African American. But that class, well, if you take reproductive choice, for example, there is no woman of even moderate means that can't get an abortion if she wants one someplace in the United States. All she has to have is the money to travel and to take off the days from work, because many states have a waiting period, 24 hours, 48 hours. And poor women need their jobs badly and can't afford to take off 2 or 3 days of work. That's just one example of how the law not just leaves out poor women, but puts them in a cage that no woman of means encounters. So I think it's very important that the equal rights of men and women be not just for women of wealth, but for all women.
Thank you. So 2 weeks ago, we celebrated your 25 years on the court. There are pictures of your swearing in all over Facebook. You probably didn't know you were trending. Since then, our ideas about sexual identities and the gender binary and the roles of men and women have evolved greatly. And of course, these have been aided by your opinions in both BMI and Obergefell. What do you see as the area of life that is most resistant to the principle of gender neutrality?
I would mention two things. First is what's called unconscious bias. And a good example of that is the symphony orchestra. When I was in my growing up years, I never saw a woman in a symphony orchestra. Or perhaps there was one playing the harp, but that was it. When, can you hear me in the background? Someone came up with a brilliant idea. Let's drop a curtain so the people who are conducting the audition won't see the people who are auditioning. And with that simple device, there was almost an overnight change in the composition of symphony orchestras. There was a critic for the New York Times who swore that he could tell the difference between a man playing the piano and a woman. They blindfolded him, and they had men and women play for him, and he was all mixed up. And he wrote about that experience, that was it for him. He saw a woman, and well, she couldn't play as well as a man, but when he didn't see her, unfortunately, we can't replicate the drop curtain in every area of human activity. When I told this story at a music festival a few years ago, a young violinist came up to me and said, "You left out something." Well, what did I leave out? We auditioned shoeless, so they won't hear a woman's heels coming on the stage. A good example of the operation of unconscious bias was a case from 1978 brought against AT&T for not promoting women to middle management positions. It turned out the women did as well as the men, at least as well as the men, on all the criteria, up until the very last one, which was called the total person test. And that consisted of the interviewer sitting down with the candidate for promotion and having a conversation. Women dropped out disproportionately at that last step. And why? When an interviewer is facing someone who looks like the interviewer, there's a certain comfort level. I know what this person is like. But if it's a person that's different, a different race, a different gender, there's a certain discomfort on the part of the interviewer. And that is reflected in the decision to promote the man rather than the women. Well, how do you attack that? There was one decision some years ago by the European Court of Justice. It's the highest court for the European Union. They have an equality provision in their basic charter, the Rome Treaty. And the particular case was a province in Germany that had a regulation in a field in which women have been largely excluded in the past. If we have two candidates of equal qualification, the woman should be preferred. When that was challenged as a denial of equal rights to men, the court said, is this really a preference for women? Or is it overcoming the unconscious bias that keeps them out of those jobs? In many European countries, they have dealt with this problem by setting numerical targets. That is, 40% of every corporate board has to be women. X% of the legislature has to be women. In this country, there's great resistance to quotas because of the history of quotas. For example, I went to Cornell University from 1950 to 1954. There was a restrictive quota for women. There were 4 men to every woman. Stanford University, written right into the grant, was women must never be over 40% of the students. So the history of restrictive quotas is still in the minds of many and leads them to resist the kind of positive numerical targets.
There was a second area that you said was especially
yes. It's what's called it's called the work-life balance. That every family can have 2 earners and should have 2 parents. One illustration of that problem, a personal illustration I'll tell you about. My son was a rather lively child. His teachers called him hyperactive. I was called at least once a month to come down to the school to be told about my son's latest escapade. And one day, when I was particularly weary, I stayed up all night writing a brief, and I got this call, come down right away. I said, this child has 2 parents. Please alternate calls, and it's his father's turn. So my husband, who had a wonderful sense of humor, he goes down to the school, and 3 stone-faced people will tell him, your son stole the elevator. It was a hand-operated elevator. The elevator operator went out for a smoke. One of my son's classmates dared him to take the kindergartners from the 1st floor to him. So when confronted with his, your son stole the elevator, my husband's response was, he stole the elevator. How far could he take it? So I don't know if it was Marty's sense of humor, but there was no quick change in my son's behavior. Still, the calls came barely once a term, because there was much more reluctance to take a man away from his work than a woman away from hers. I'm glad to see that many of my law clerks have taken paternity leave. A police officer who was with me this summer was on paternity leave. I would think it should be much easier with all of the advances in electronic communication to have flexible work schedules for people. It hasn't yet worked out that way. And I'll give you another example. So my very first year on the Supreme Court, I asked a man who had clerked for me on the DC Circuit to come back and clerk at the court. he was so attractive to me because his application said, I'm going to Georgetown at night because I'm the principal caretaker of my two children. My wife has a very good job at the World Bank. And also, he submitted as his writing sample what he had for his first year writing class at Georgetown, and it was the idea of contract as illustrated in Wagner's Ring Cycle. Well, anyway, so he clerked for me on the court. He still picked up his daughter at her soccer matches. I asked if he could have access to Westlaw and Lexis at home. And my chief told me, absolutely not. That's, only the justices can have it at home. So I say, well, I can have it at home, but I don't use it, so. And nothing doing. The next year, every law clerk had access to Westlaw and Lexis at home. So that's something that I can see with my own children and grandchildren. My son and my grandson are both wonderful parents. And I have in my chambers a picture of my grandson when he was 2 months old, and his father is looking at him with, they're both on the bed, and the father is looking at this child with adoration. Very recently, I put another picture next to it. It's my grandson, at 2 months old, now 31, and his first child, his daughter. And it's the same adoration of the father for the child. And I would say that if all men related to their children the way my son and grandson do, the world would be a better place.
So I love the part of your book about your bench descents. You probably know that there is an entire line of jewelry based on your descent collar. They're pins, they're earrings, it's everywhere. Yes.
This is a very limited edition. You can't buy it. It's done by the publisher of I Descent, which is a children's book. It's very popular because it tells children it's okay to say no.
So my favorite quote from the Shelby Voting Rights Act case is, throwing out preclearance is like throwing away your umbrella in a rainstorm because you are not getting wet. We are here on Women's Equality Day, marking the passage of the 19th Amendment that allowed some women the right to vote. What were some of the messages you got about women's political and civic participation when you were growing up, including the duty of the right to vote?
My mother remembered as a teenager marching in suffrage parades. But as to the gender-based differential that pervaded state and federal law books, I can't say that she rebelled against them. She thought that it would be fine if I would be a high school history teacher, because teaching was a profession in which women were welcome. So it wasn't until later that I appreciated how irrational it was to keep women from any field which they aspired, and I'm heartened by the change. In my years at Cornell, there was only one woman in the engineering school. 2 years ago, I went to VMI to celebrate, it was the 21st anniversary of the decision. And I met with the women cadets. Many of them were in the engineering program. The point is that there should be no closed doors, that a woman should be able to aspire and achieve if she's willing to put in the hard work that it takes to do that. Girls and boys should grow up thinking, as there's a once famous song by Marlo Thomas. It's in a series that had been put out by Ms. Magazine, and it's free to be you and me, free to be what I want to be because of my talent. A wonderful illustration between the difference between girls growing up then and now. So when my granddaughter, who's now a lawyer, was 8 years old, she was with me, and I was being filmed for something. And my granddaughter said, "I want to be in the film." So the filmmaker said, "Fine, Clara, what would you like to be when you grow up?" And this 8-year-old child said, "I would like to be president of the United States of the world." When little girls can think like that, it's a huge difference.
It is. And much of that difference is by your hands, so thank you. We're going to take some questions from the audience. Thank you.
Let's take a minute just to fix the mic so we can all hear a little better.
And we can return this to it. Yeah. Okay, does it sound better?
Oh. All right. What is the one case you think had the biggest impact on women, either that you litigated or made a decision in?
Reed v. Reed, not because the immediate decision changed a lot, but it changed the Supreme Court. It was the turning point case. Up until 1971, the Supreme Court never saw a gender-based classification that it didn't like, or at least think was okay. So we could start with the women after the 14th Amendment who argued, I am a person and I am a citizen. Therefore, I should have the right to vote. And what the Supreme Court answered in that case, I think it was from the 1870s. Virginia Minor was the plaintiff. And that was her argument. I am a person, a citizen, therefore I must have the most basic right of citizenship to vote. And the court said, of course you are a person, and you are a citizen, but so too are children. And no one would argue that children should have the right to vote. And she was turned away just that way. The next case, Myra Bradwell, a woman who met all the qualifications for membership in the bar of the state of Illinois. She was denied membership for one reason only. she was a woman. When that case came to the Supreme Court, the state of Illinois was so sure it would win, it didn't even send a lawyer to argue the case. And the Supreme Court said it was permissible to exclude women from the practice of law. Then we get up to 1948, and this is after the what happened? After the during World War II, when many men were off fighting, and some professions were left in need of people. One of them was bartending. Many women became bartenders during the years of World War II. A mother and daughter, Gossett was their name. The mother owned a tavern, and her daughter was her bartender. Michigan passed a law stimulated by the Bartenders Union that said no woman can serve as a bartender unless her father or her husband own the establishment. The Gosserts argued, this puts us out of business. Well, the Supreme Court said of that case, first it said something that really didn't fit with what its judgment was. It talked about Chaucer and the alewife. But then it said, unpleasant things go on at bars, and the state has the right to protect women against the boisterous men that frequent bars. The Gossett case had a happy ending. After the Supreme Court said it was okay to exclude women from bartending, the Michigan Commissioners of Alcohol decided, oh, forget it, we're going to leave the Gossetts alone, and we're not going to enforce this law that it disallows women from serving bar. But that's where the court was. And as late as 1961, they get the case of Gwendolyn Hoyt, a woman who had a philandering, abusive husband. And one day, he had humiliated her to the breaking point. She spied her son's baseball bat in the corner of the room. She reached for it, and with all her might, hit her husband over the head with it. He fell on the stone floor. That was the end of their altercation and the beginning of her murder prosecution. Gwendolyn Hoyt was from Hillsborough County, Florida. Hillsborough County did not put women on the jury rolls. Gwendolyn Hoyt's thought was, I'm entitled to a jury of my peers. If there were women on that jury, I'm not saying that they would acquit me, but they very well might understand my state of mind and convict me of the lesser crime of manslaughter and not murder. She was convicted of murder by an all-male jury. And the so-called liberal Warren Court in 1961 said that was okay. Why? Because women are the center of home and family life, therefore they shouldn't be distracted from their care of children and home sitting on juries. Then the court said they have the best of both worlds. If they want to serve, they can go down to the clerk's office and put their name on the rolls. But if they don't want to serve, they won't be called. Well, citizens have obligations as well as rights, and one of those obligations is to participate in the administration of justice. If the state doesn't put women on the list, the state is saying we need the men, they are essential to the administration of justice, but women are expendable. We don't really need them. If they want to serve, okay. That says something about the attitude of the lawmakers to women, that they are expendable. There was a change in the 1970s, starting with Sally Reed's case. Sally had a son. She and her husband divorced. She had custody when the boy was what the law calls of tender years. When the boy reached his teens, the father applied for custody. His argument was now he needs to be prepared for a man's world. Sally fought custody for the boy's father, and sadly she was right. The boy became increasingly depressed in his father's home. One day he took out one of his father's many guns and committed suicide. So Sally wanted to be appointed administrator of his estate, not because it had any monetary value. What was there? There was a small bank account, there was a guitar, there was a record collection, some clothes. That's about it. But for sentimental reasons, Sally wanted to be appointed. Her ex-husband applied a couple of weeks later. Sally thought she would get the appointment because she applied first. The probate court judge said, "The law compels what I must do." It reads, "As between persons equally entitled to administer a decedent's estate, males must be preferred to females." So that was the law that Sally successfully attacked. And it was the beginning of a whole series of cases in which the court struck down laws as making impermissible gender-based differential. So Sally Reed's case was the trigger for the cases that came after.
Thank you. Based on these cards, there are a lot of stressed out people out there. They're looking for inspiration, and they want to know your advice for those who are fighting in this movement, who need guidance, who need sustenance, who want to know where they should focus their energies. What advice do you have for them?
The advice that my mother-in-law gave me the day I was married, and I was married in her home. Just before the ceremony, she took me aside and said, "Dear, I would like to convey to you the secret of a happy marriage." "Oh, I'll be glad to know. What is it?" "It helps sometimes to be a little deaf." And that was advice I followed for 56 years of marriage, and in my workplace to this very day. You know, when a thoughtless or unkind word is said, you tune out. You don't hear it. You don't snap back and react in anger. So that be a little deaf is good advice. Emotions like anger get you nowhere. So I'd say, in addition to being a little deaf, being patient. If you don't win the first time, you try again. And have a sense of humor. That really helps. I mean, in the bad old days, when judges knew that it was you don't make racist comments, they still thought that women were fair game. So I was arguing before a 3-judge federal district court, the Weisenfeld case, before it went to the Supreme Court. And one of the judges said, well, I understand today women can do whatever they want, even in the military. And I responded, Your Honor, the Air Force doesn't give flight training to women. His response, dear, don't tell me that. Women have been in the air forever. I know from experience with my own wife and daughter. So what do you say? You don't say, you sexist pig. You say, Your Honor, I know many men who don't have their feet planted firmly on the ground. And then go ahead with your argument. I mean, the man who was later my chief, in the very last argument I made before the court, 1978, and it was about jury service again. The state of Missouri had an exemption for any woman. So they put women on the roll, but they sent a card and said, if you are a woman, you are not required to serve. If you don't want to serve, check off here. And if the card wasn't returned, the assumption was the woman didn't want to serve. I divided the argument with the Kansas City, Missouri public defender. I had a precious 15 minutes. I was about to sit down when then Justice Rehnquist said, so, Mrs. Ginsburg, you won't settle for Susan B. Anthony's face on the new dollar. It's a silver dollar created for her. This is the same man who, when he became chief, wrote the decision upholding the Family and Medical Leave Act. He also voted for the judgment, although didn't sign on to my opinion, but he voted for the judgment in the VMI case. So he is my illustration of, as we live, we can learn.
Absolutely. What are your thoughts on the role of lesbian, bisexual, transgender, and non-binary individuals in the larger feminist movement?
The idea of the feminist movement is that we are all equal in the rights the government should give us. And I think this is, you know, for so many years of my life, if you weren't identifiably male or female, you were in the closet. The way to take away a security clearance for a male was for someone to accuse him of being homosexual. It's exhilarating to see how far, how fast that movement has come. And it's come about, yes, there were decisions, but before the decisions, there were people who said, we are going to stand up, we are going to say who we are, we're going to say that what we are is okay. We're proud of it. And I think if that hadn't happened, there never would have been an Obergefell decision. It has to start with what's called a critical mass of people. So I remember when I was on the post-legal education committee for the New York City Bar. The Gay Activists Alliance asked if they could have a program explaining the difficulties they encountered in renting an apartment, in having a dentist willing to care for them. So I was the only woman on the committee. And every program has to have a committee member to superintend it. And when none of the men volunteered, I said, well, I'll be responsible for the program. And then there was some giggling. What was so funny? Well, Ruth, they might feel uncomfortable dealing with you. So I said, what makes you think that everyone who has a same-sex preference is male? And the Gay Activists Alliance sent their vice president, who was a woman, to make this presentation, which was very effective. So I think what's important is it has already happened. People saying, this is what I am, and it's okay.
So describe what it is like on those mornings when you're putting on your dissent collar and knowing that you're going to read one of your dissents from the bench, especially in those areas that deal with women's rights and equality or voting rights. So those issues that are most meaningful to you. What's the mindset when you're going into these dissents?
If it's a statutory question, it can be fixed by Congress. And my best example of that was the Lilly Ledbetter case. Lilly had been working as an area manager for the Goodyear Tire Company. When she was hired, she was the only woman doing that job. She'd been working there 10 or dozen years, and someone put a slip of paper in her mailbox with a series of numbers. Lily recognized immediately what those numbers were. It was the pay of all the area managers, and she sees that she's being paid the least. The young man that she trained is earning more than she is. So then she said, okay, I've had it. I'm going to sue. She brings a Title VII lawsuit. She wins in the trial court. Considerable. The case was tried to a jury. She got a nice compensation award. Gets to the Supreme Court. Supreme Court says, Lily, you sued too late, because Title VII says you must complain within 180 days of the discriminatory incident. And here Lily is complaining years and years after. And I explained in my dissent that a woman who is taking a job once held exclusively by men does not want to be seen as a troublemaker. She doesn't want to rock the boat. And besides, suppose she had sued early on. First, she would have had to know what the pay figures were. Employer wasn't giving those out. But if she had sued early on, no question what the defense would be. It has nothing to do with Lily being a woman. She just doesn't do the job as well as the men. Well, now she's worked there a dozen years, and she has consistently got good performance ratings. So she has a winnable case. That defense, she doesn't do the job as well as the men, is no longer available. The employer's own records show that she has done the job at least as well as the men. But the court said she sued too late. It was a simple theory. It was used in equal pay cases by the Department of Labor. That is, each paycheck you receive renews the discrimination. So you can sue within 180 days of your latest paycheck, and the suit would be timely. The tagline of my dissent was, "The ball is now in Congress's court to correct the error into which my colleagues have fallen." And in very short order, with a coalition of people supporting it, Congress passed the Lilly Ledbetter Fair Pay Act that adopts the paycheck rule. So you're timely if you sue within 180 days of the renewal of the discrimination. If it's a constitutional question, then Congress can't fix it. So you're writing the dissent. Your audience is a later court that can see the error that an earlier court made. And we have a history of dissents of that kind. And going back to the worst case the Supreme Court, worst judgment it ever issued in the Dred Scott case, there were 2 dissents in that case. The one by, what's his name? Justice Curtis, particularly good. In the separate but equal cases, Plessy against Ferguson, the first Justice John Marshall Harlan dissented, as he had about 13 years earlier in the so-called civil rights cases, where Congress had passed a law saying access to places of public accommodation, hotels, restaurants, theaters, cannot be denied or restricted on the basis of race. And the court said Congress didn't have any authority to do that. Those regulations were state business, not federal. So there was a dissent from that. Justice Holmes and Brandeis were famous for dissenting in free speech cases around the time of World War I. All those dissents are today the law, because a later court, in the case of separate but equal, the Brown court recognized the error that an earlier court had made. So that's one audience statutory question. Your immediate audience is Congress. Constitutional question, you're arguing for a later court.
Thank you. So turning back to the ERA, one of the main arguments against the ERA is that it's going to lead to all of these unintended consequences. What would be your response to that? You are, of course, are very clear on what the intended consequence is, but what would be the response to the unintended consequences?
During the time that I was lobbying for the ERA, one thing that was brought up all the time was same-sex bathrooms. Well, the airlines had a perfect solution to that. A locked door. Then another major objection, well, women will be subject to the draft. And I think that's right. We have seen an enormous change in what women can do in the military one after another, the occupational barriers have fallen. So I think back to 1972, when I had a client with a case that I wanted to be the first reproductive choice case to come before the court. So it was Captain Susan Struck. She was a nurse in the Air Force sent to Vietnam. While there, she became pregnant. All of the services had a rule: if you're pregnant, you're out. Captain Struck said, I will use only my accumulated leave time for the birth, and I have arranged for the child to be adopted at birth. But I'm Roman Catholic, and I can't do what the base commander said I would have to do to remain in the service, that is, have an abortion. And people don't realize that in 1972, many military bases were providing abortions for wives of servicemen and for servicewomen. But that was not a choice Susan Struck could make. She argued, you see, there's so many people who got hooked on alcohol or drugs while in service. If they report themselves and put in rehab programs and they're not discharged, I'm going to be out a much shorter period of time than the men that you keep in. The Supreme Court had granted cert in her case, and then the Solicitor General told the Air Force, this case has lost potential, better allow Captain Struck to remain in service. So they waived her discharge, and they changed the regulation prospectively, so that pregnancy was no longer a moral and administrative ground for discharge. I called Susan Struck to try to keep the case alive. So I asked her, are you out any pay and allowances? No, she's gotten all that. Well, she doesn't love being in Minot Air Force Base in South Dakota, but can't say she was sent there as any kind of a penalty. Then she said, there is one thing. All my life, I've dreamed of becoming a pilot. And then we laughed, because we knew that 1972 was too early to push that argument, that flight training should be available to women. Now, I think, yeah, if flight training was still denied to women, that would be certainly a winnable case. So what was the question?
The question was unintended consequences. Yes.
Oh, yeah.
That's how you got to the military.
So I did the bathroom and military service, and then the Equal Rights Amendment will destroy the home and family as we know and love them. Why that should be the consequences of recognizing the full equality of both parents, I can't fathom.
Thank you so much for generously answering the questions. And we are going to have some closing remarks. And then, of course, we will take a picture with you in our midst. Mm-hmm. Thank you.
Good evening. Sorry, let me try that again with the mic. Good evening, everyone. The National Women's Party would like to thank the phenomenal Justice Ruth Bader Ginsburg, our dynamic moderator, Jill, and the tireless leaders of the women's movement represented here joining us for this conversation. Wow. This is a bucket list moment for me. I'm not sure about those of you in the audience, but can we just give a round of applause one more time? I'm humbled and honored to look around this room and see standard bearers who inspire with their commitment, dedication, and innovative leadership. And of course, I mean, in addition to Justice Ginsburg here. As we all know, 2020 marks the 100th anniversary of the 19th Amendment. Yet despite much progress, women still face harassment, violence, pay inequity, labor discrimination, and other injustices. We are all here to change that. This is a pivotal moment, one which we will make a turning point in the fight for women's full equality. And if the energy in this room is any indication, we are well on our way to that goal. In honor of the centennial and our brave and diverse predecessors, we at the National Women's Party are renewing our commitment to achieve full constitutional equality for women. The National Women's Party has a bold new vision rooted in our historic mission, premised on inclusion and education. We will harness our past to inform and advance the modern effort for women's rights. In this critical moment of civic engagement among women, we see in today's resistance, Me Too, and Time's Up movements. We are committed to working with you, leaders of our movement, to amplify our respective work and thereby finally realize the goal of women's equality. We will leverage our relationships, activist roots, and rich history to support the efforts of partners and allies in this room and around the country. We want to know how we can help your efforts to move an equality agenda forward. And we have seen time and time again that in the history of our movement, when we come together, we win. To that end, this fall, the National Women's Party will launch a national initiative to inspire action towards this goal. We will engage and inspire communities across the nation through local exhibitions of our historic collection of women's history, convene interactive discussions related to women's equality throughout the nation, and excite people to act. Host educational planning and leadership events that harness and amplify the energy of today's women's rights movement. These efforts will continue well beyond 2020 as we work together to achieve equal treatment for women under the law, regardless of sex, socioeconomic status, race, sexual orientation, gender, or gender expression. It is fitting that we are gathered in the historic headquarters of the National Women's Party, once again inspired by an early catalyst and crusader for women's equality and civil rights. In many ways, we have come full circle, reclaiming our roots with a thoughtful eye towards the future. We didn't always get it right in the past. Our history is marred by how we treated our sisters and brothers in the cause. We are conscious of those mistakes and vigilant as we look towards the future. The diversity of backgrounds, causes, and opinions represented in today's gathering is one step in the right direction. You'll be hearing a lot more from us in the coming weeks, months, and years as we reaffirm our voice in the movement towards equal rights for women. Just as our founders were over 100 years ago, we will be bold and use all of the resources at our disposal to advance our movement. We will build our history, learn from the mistakes of the past, and work with allies, starting with those of you here with us today in the fight for full equality. Since 1913, the National Women's Party has worked tirelessly across the country and the world to advance women's rights. We look forward to continue working with you all in this fight because simply equality cannot wait another 100 years. Thank you all for joining us this evening.